could be a pretty complex concept, as you may have, oftentimes when we speak to people, they tell me, I don't have employees, all I have are 1099s, or vice versa. So we do have a definition, under the Wage and Hour Division. It is focused on protecting the workforce and supporting essential workers who continue to move forward. That is one of our public, what we want the public to know at this time. And under misclassification, there's different laws that we enforce. I do want to show the disclaimer. And this one in particular is very important. I know that I'm not going to read it all, but one of the things to keep in mind is that the regulation and the publications that are available is ultimately what prevails. So we have the Federal Register and the Code of Federal Regulations remain the official source for regulatory information published by the Department of Labor. I say this because things are often changing. So as we speak, this is one topic that I will make these available in the back. There has been a decision, and it provides up-to-date information. So at the very top, this is what we call a fact sheet. It gives really easy-to-read information. I love these personally because it breaks it down in language that we understand. And I say we because as an investigator, I used to go to these all the time. So I will put these in the back, and it particularly talks about employment relationship under the Fair Labor Standards Act, which is what I was here to speak about today. So as I was putting this presentation together, this is one of the items that came up. So one of the items was updated. So we enforce the law for 10 million establishments nationwide, and 148 million workers are covered. So that's more than 200 offices throughout the country. We have one here in San Antonio. Ours is actually located off by the old San Francisco Steakhouse. That's the easiest way for me to describe it. So off of North Star Mall. And more than 200 languages are spoken. If we don't speak the language that you are calling us, we have translating services. This provides some statistics, some information. Once again, we will have this available for individuals. And I can actually, if you would like for me to present it, if you would like for me to go into detail, I'd be more than glad to. And we provide information for workers and for employers. So we provide it to whomever takes it pretty much. So we provide it in a way that's understandable. So this priority, so particularly the understanding the classification, it's a priority because it could potentially impact your minimum wage, overtime, record keeping, family and medical leave, as well as other federal and state laws. So you think, well, why do y'all care about this in particular? Well, it could ultimately have an effect on all those other items. And misclassification can occur when a worker is considered an employee under the law, but treated as an independent contractor by the employer. And it applies whenever there is an employment relationship between an employee and an employer. Most workers are employees under the Fair Labor Standards Act. And that's the Fair Labor Standards Act of 1938. And it could occur in any industry. Sometimes we're called, well, that only applies for construction. That doesn't apply in restaurants, or that doesn't apply. It could actually apply in different industries. It's not industry specific. And it addresses inequity, and it does have some cost to misclassification. So employees could be denied the right to minimum wage, overtime pay, and other protection. It could create a tax burden on misclassified workers. It could create unfair competition for responsible companies that comply with the law, and it could lead to revenue loss for government. So this just provides a very quick overview. Like I said, I have step by step, I have certain factors. I have what we call an economic reality test that we conduct. So just because you give somebody a 1099 does not automatically make them an independent contractor, the way the Wage and Hour Division looks at it. So, the Fair Labor Standards Act specifically defines an employee to mean an individual employed by an employer, and it defines employ to include to suffer or permitted to work. So I won't get too into it. Just like I said, I wanted to provide a quick overview. And it could, once again, any industry to include janitorial, home care, child care, transportation, warehousing, meat and poultry processing industries that you may not think could be impacted. And then some misconceptions, just because they signed off on it, I agreed to it, it doesn't automatically mean that they are. And then these are the factors that I can definitely go more into detail, but there's certain factors that we look at. But my presentation does specifically say to look at fact sheet 13, and that's what I have here. And that provides the updated information. So I think I will cut it off here just for the purpose of time. But once again, just because somebody tells you you're a 1099 or provides you that contract does not automatically mean that you are an independent contractor. So we look at the economic reality and at the work you're performing. So, and once again, take a look at the presentation. I was speaking about the economic reality of the workers' relationship, and then certain factors that are discussed. So I'll go ahead and I'll conclude it for now. And like I said, if you have any questions, feel free to reach out to me.